So the Electoral Commission's latest move to seek clarity in Section 47 of the Constitution has received mixed reviews. The IEC has approached the Apex Court on the matter. This follows an Electoral Court ruling that reversed the Commission's decision to remove former President Jacob Zuma from the general election ballot on the 29th of May. Well, initially the IEC said Zuma was not eligible because he had been sentenced to 15 months in prison for contempt of court. Well, the uMkhonto weSizwe party says the electoral body overreached its mandate. Well, let's get further insights and analysis on these developments now with constitutional law lecturer at Stellenbosch University. We are joined by Tanveer Jeewa. Tanveer, good morning to you. Thank you so much for joining us. For me, this is one of the most interesting conversations because we're going up to what people are calling one of the most intensely contested elections of our very own democracy. And already we're having the Electoral Commission wanting to go to the Constitutional Court to argue whether a lawmaker can be considered, as one of the lawyers, certainly Tanveer has argued, that lawbreakers cannot be lawmakers. What do you make of this entire discussion? Is this a good precedent that we're setting for our democracy?
Well, thank you so much, Naledi, for having me. It's definitely a good case to be going to the Constitutional Court. I don't think we need to talk about precedent yet because we don't have reasons from the Electoral Court, which is why we hopefully will have something from the Constitutional Court. And then looking from the reasoning, we'll see whether it would be a good precedent or not to be setting. But it's definitely a matter of huge interest to all constitutional law scholars, but also everyone interested in politics because, as you've mentioned, it's one of a kind. This has never happened before, and it involves a lot of interpretation of just different rules. Most importantly, whose responsibility is it to handle who gets to make up the National Assembly, right? A lot of debate around that, really.
Yeah. What do you make then of and how you interpret Section 47 of the Constitution and really how it relates to this matter, right? Do you think that once the Electoral Commission is able to go towards the Constitutional Court, that we would see them being successful? I mean, the likelihood of that, in your view?
Look, I do personally think that they will most likely be successful. And the reason for that is because Section 47 obviously relates to the way in which the National Assembly works, who gets to be a member of the National Assembly. It is a good argument to say that the National Assembly is supposed to be handling its internal dealings, right? Because that is definitely true. But the issue with this argument is that whoever makes up the National Assembly is not part of the internal dealing of the National Assembly, right? That is guided by whoever is voted in. And who is responsible for who gets to be on the electoral list to be voted in? It's definitely the Independent Electoral Commission, right? As a Chapter 9 institution of the Constitution, they are responsible. There's a constitutional duty to ensure that there are free and fair elections. So is the election really free and fair if someone who is not eligible to be part of the National Assembly gets to actually be part of the election? And that's definitely the question that the Constitutional Court will need to be looking at. And I think there's a likelihood to win because it is in all probability the IEC's responsibility to see who gets to constitute the National Assembly, because it cannot be that the National Assembly itself vetoes who is a member, especially because if someone is not properly and legitimately on the ballot, they will not be properly and legitimately part of the National Assembly who gets to make that decision. It's a circular reasoning that probably won't work.
Yeah, I want to read from Section 47 of the Constitution, because one thing that we might not actually do is actually provide South Africans with what that section actually says, right? And I'm going to do that in a moment, but as I just find it quickly, let's paint a broader picture, right? And imagine then that the former president is successful in this bid that we're seeing the IEC then trying to chase with the Constitutional Court. Let's say that the former president is able to stay on the ballot and contest in the 29th of May elections. After those elections have taken place, could we see a constitutional matter also approaching the courts there, where there is a question around whether or not he can enter the National Assembly?
that's probably going to be very tough, because there's no way the Constitutional Court now will be able to make a decision without considering the exact legal issue that you brought up that might be considered later, right? Which is, can someone who's convicted, who ran through the elections, actually make part of the National Assembly? They undoubtedly have to face that issue now. And once it's been decided, you can no longer go to the court for the same issue. It's known as res judicata, which is when the courts are not able to decide two matters at the same matter twice.
Yeah.
Right. So it won't be as well.
Yeah. So this is what the Section 47 of the Constitution actually says. Anyone who, after this section took effect, is convicted of an offence and sentenced to more than 12 months imprisonment without the option of a fine, either in the Republic or outside of the Republic, if the conduct constituting the offence would have been an offence in the Republic, but no one may be regarded as having been sentenced until an appeal against the conviction or sentence has been determined, or until the time for an appeal has expired. I mean, it gets quite technical when we get to this point, right? And I think that there's something to be said about the fact that we're using the courts then, at this point, to decide who can stand for the leadership of our country. Is that concerning, that we're seeing politicians then using the courts to have these debates around what's written in the Constitution?
Look, I would say that anyone would be a liar to say that it's not concerning. There are deep separation of powers issue. Obviously, you don't usually want the judiciary to meddle with things that relate to vote and who gets to be part of the National Assembly. And that's why usually, based on precedent of the Constitutional Court, they hesitate to interfere, and they hesitate to even declare elections unfair. But as you've mentioned, the Section 47(1)(e) does get very technical. And whose responsibility is it really to interpret the Constitution? You do want the most specialist body to tell you what that Constitution means, right? So I won't lie and say that it's not necessarily a little bit alarming whenever there's the courts involved, but it is necessary in this case. It's just that the court will have to be a little bit more wary of just how much it interferes, and just to make sure to minimize that interference, really.
Yeah. What do you think the lessons are that really can be learned in this case, rather, to improve the electoral system of our country?
Yeah, I think if there is a Constitutional Court judgment, which I hope there will be, there is precedent on how to interpret a lot of sections that we've never had to really, grapple with before. Because I think we do need to take into account who the applicants, or rather who the parties are. It is obviously very contentious, precisely because it involves ex-President Jacob Zuma. So I would have hoped that conversations like that can happen without mentioning the parties. But at the end of the day, the reason why the public is so worried about what's going on right now is because the alarm is raised when it comes to the legitimacy of the elections, right? South Africa has had a good run of legitimate elections, free and fair elections, but we always need to be worried about the perception of the elections as well. So that's why I mentioned that the court really has to be careful when it comes to the way in which it interprets. But in many ways, we do need to look at the role of the IEC as well when it comes to handling free and fair elections. What does that involve? How much must they be involved when they contest decisions? And in this case, I'm hoping that we do get a lot more about the IEC's power, and hopefully it also eradicates all of the crisis of legitimacy that is likely to happen when cases like that come to court, right?
Yeah, I think just to close off, and perhaps I'm being an optimist, Tanveer, but I see a great opportunity here as well for the electorate as we have this race towards the 29th of May polls. A great opportunity here where the electorate is actually learning about constitutional processes and constitutional systems, and really the laws that make up our country. Am I being utopian?
No, you're absolutely right. Look, at the end of the day, we must be quite honest. It's almost impossible in South Africa to have an election year without an urgent application to the Constitutional Court.
Yeah.
Always happens. Last time it was about independent candidates, and we got a better democracy for it, right? Much more transparent. Now you have independent candidates. Absolutely. So I can only agree with you and hope that it's for the best and we actually get good precedent out of it, and we all understand South African democracy and make it a little bit more transparent and better for the future, truly.
Yeah. Absolutely. Thank you so much for your time. We really, really do appreciate it. And we look forward to chatting some more in the future. That there is constitutional law lecturer at Stellenbosch University, Tanveer Jeewa.